there are few very important aspects or few most frequently asked question in every single subject. And if you ask me what is one such topic in company law, I will definitely say it is separate legal entity. Yes, separate legal entity can be an independent question, or you might have a question on Solomon versus Solomon and Company Limited case law, or Lee versus Lee A Farming Limited case law, or it can be Condoli Tea Company Limited case law. There are so many case laws, and that's why this becomes a very important topic. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in this series of company law, we were discussing natures and features or natures and characteristics of company. And in that series, this is my fourth video where we are going to discuss the seventh nature or characteristics of the company, that is, companies are separate legal entities. And as I said, I am going to discuss this topic with lot of case laws. To be precise, there are 8 case laws that I am going to discuss, and that's why this becomes a very important presentation. Not taking much of your time, let's get into the first slide. In our last 2 videos, we have discussed the first 6 nature and characteristics of the company, and here in this video, we are going to understand the 7th nature and characteristics of the company, which is also the first among the scope of the company, that is separate legal entity. This is one of the most common questions asked in company law, and hence we are understanding this in detail with lot of landmark judgments. First thing first, let us understand the concept of separate legal entity in my next slide. As we all are aware, in partnership, we are not separating the partners from the firm or the firm from the partners. There, both the assets and liabilities extend to both of them, whereas when it comes to the concept of the company, it is completely different. Company is a different person altogether from its subscribers, and that's why we call company as a separate legal entity. Before we understand how company is separate from its subscribers, let us quickly go through what one of the judges has to say in the case of Solomon versus Solomon and Company Limited. Lord McNaughton in his first line says that, and I quote, "The company is at law a different person altogether from the subscribers," unquote. Here he says company and its subscribers are different persons. Further he says, and I quote, "Though it may be that after incorporation the business is precisely the same as it was before, and the same persons are managers and the same hands receive the proceeds, the company is not in law the agent of the subscribers or trustee for them," unquote. What is he saying here? He is saying after incorporation, the business might be same and the people who are running the show might also be same, but that doesn't make the people as the agent or trustee for the company in the eyes of law. I hope you guys are understanding it very clearly. He further says, and I quote, "Nor are the subscribers as members liable in any shape or form except to the extent and in the manner provided by the Act," unquote. Here in this line, he continues and says that the members are not liable or responsible for the Companies Act, whatever it is. In a nutshell, he makes it very clear that neither company is an agent or trustee of its members, nor members are liable to Companies Acts. I hope that's very clear. Now, let's quickly understand that how company is a separate legal person or a separate legal entity. First thing, just like you and me, company has its own name. Not just name, but also has its own seal. Further, company has its own legal rights and obligation. These rights and obligations are completely separate from of those running or owning the entity. The next very important part which proves that company is a separate legal entity is that the company has its own assets and liabilities, like owning the property, incurring debts, borrowing money, having a bank account, etc. Unlike partnership, no member, either individually or jointly in the case of company's existence or winding up process, can claim the right of ownership in the assets of the company. Company can employ people to achieve its very purpose, and it can enter into contracts. Lastly, company can sue and being sued separately. I have given an example there that for company's creditors, members are not liable, and the similar way, company is not liable for members' personal debts. Finally, look at that box where I have tried to convey that even if a single shareholder virtually holds the entire share capital, a company is to be differentiated from such shareholder. That is the gravity of the separation, and we will understand it in the Solomon's case as well as Lee's case. Saying about case laws, though Solomon's case law is very famous whenever we discuss this topic, we should always remember that a decade earlier to Solomon's case, Kolkata High Court had given a landmark judgment on this topic, and let's start the case law discussion with that particular case, which is the Condoli Tea Company Limited versus the unknown in my next slide. Whenever we discuss about the matter of company is separate legal entity or company is a separate legal person, we always jump to Solomon versus Solomon and Company Limited case. Whereas we missed to take a note that our own Kolkata High Court had very clearly defined this legal concept in the case law of the Condoli Tea Company Limited versus unknown. This particular judgment here came at least a decade prior to the Solomon's case. What happened here? 8 men formed a company. Not of those who are in the image that I have provided here. That's a random Google image. I downloaded and pasted so that you guys remember that this case law is about the 8 men. Okay? Coming back to the case law. As I said, the 8 persons formed a company. They had certain personal tea estates and they transferred them to company. Now, while doing this transaction, they were supposed to pay a tax under Article 21 of the Stamp Act, which is known as ad valorem duty. They denied to pay this duty in the pretext that the land is of our own and the company also belongs to us, as we are the subscribers, and hence the transaction is mere conveyance and hence we are not going to pay the duty. That is what their claim was. But in the judgment, Chief Justice W.C. Petheram said, and I quote, "I think that is a fallacy. Whoever is the shareholder in the Condoli Tea Company Limited were, I think the Condoli Tea Company Limited was a separate person, a separate body, and a conveyance to the Condoli Tea Company Limited a property which was the property of the sharers in their individual capacity was just as much a conveyance, a transfer of the property as if the shareholders in the company had been totally different persons." Unquote. That's quite simple and straight English. The word meaning of fallacy is myth or misconception or mistake. In a nutshell, it is to say that if someone thinks that just because they are the subscribers of the company, they and company are one and the same, that's completely wrong. Hope that is very clear. That's the first case, and with that I am taking you to the second and one of the most important case law of company law, that is Solomon versus Solomon and Company Limited case law. Solomon versus Solomon and Company Limited is the heart of discussion when it comes to company is a separate legal entity. This case law in a way a starting point for discussion on corporate veil. Very interesting and very important case law, and let us try understand this case law with the help of charts. As this case law is very important and has lot of details, I have segregated the story into 3 major parts. I have done lot of research before I put details and figures in each place, but I can't conclude that all the data here are perfect. While studying company law, these numbers are anyhow not that critical, whereas you need to understand the context very clearly. I hope that is very clear. With that, let's get into the story. First thing first, let us try understand part A of the story. One more thing, please remember that I have made this A, B, C separation to make the case law easy, as well as fit this entire story in one slide. Okay, first part goes this way. Aaron Solomon was a leather merchant and he was in the business of making leather boots or shoes as a sole proprietor. He had a wife, a daughter and 4 sons. Out of the 4 sons, two sons wanted to become the part of father's business. So Solomon decided to form a company by selling his proprietorship firm to the company. He sold his proprietorship firm to the Solomon and Company Limited to an exorbitant price of 38,000 pounds. The distribution of shares was in the ratio of 20,001 to Solomon and 1 each shares to his family members. So he had 20,001 shares, whereas remaining 6 subscribers had 6 shares. Solomon also was the managing director of the company and he made 2 of his sons as director of the company. Needless to say that with having almost all the shares with him, Solomon was running business as per his whims and fancies. Now let's move to the part B of the story. As company needed more funds, Solomon bought 10,000 debentures with 10% interest towards the same. He became the secured creditor and they also raised 7,000 pounds via unsecured creditors. Later, Solomon sold 5,000 debentures to Edmund. Now, Solomon and Edmund became secured creditors with 5,000 debentures each, whereas company had the liability of 7,000 pounds towards unsecured creditors. The business was making profit when Solomon was running it as a proprietor, whereas the whole scenario changed within a year of it becoming the company. The company went into losses, thus failing to pay the interest to the debentures. Finally, with all this scenario, the company went into liquidation. Now let's get into the last part of the story, that is part C. In the liquidation, they got the asset worth of 6,055 pounds, from which Edmund got paid fully for his debentures, that is 5,000 pounds. The remaining 1,055 pounds were paid to Solomon as he was the remaining secured creditor. The unsecured creditors got nothing and they went to the court asking that the company is of Solomon and hence all the others to be paid first, and only if anything remains Solomon to be settled, as he is the agent of the company or the company was completely of his own. The trial court and the court of appeal considered Solomon as the agent and said that the unsecured creditors to be settled first before considering Solomon himself. However, House of Lords took a different stand, saying that company is a separate legal entity. With that, Solomon got 1,055 pounds. Now you might be thinking, is this the end of it? For that particular case, yes, it was. But definitely not completely an end to this, because whenever this kind of legal question arises and when it becomes not so convincing for everyone, or when it looks like an unfair judgment, law always finds a new rule, and Solomon and similar other cases gave birth to a principle, that is principle of lifting of corporate veil, that we will discuss in some other class. While this is the heart of this presentation, we have another very important case law, that is Lee versus Lee Air Farming Limited. Let's get into the next slide to understand that particular case law. It's a legal principle that even where a single shareholder virtually holds the entire share capital, a company is to be different from such a shareholder. That's the precise discussion in Solomon versus Solomon and Company Limited, and the discussion continues in this case law as well, which is Lee versus Lee Air Farming Limited. Here in this story and in the first part of it, we need to understand that a person by name Lee formed a company and he named the company as Lee's Air Farming Limited. This company was into fertilizers on farmland from the air, which is known as top dressing. The total share capital was 3,000 pounds, in which 2,999 pounds worth share capital was held by Lee himself. He was the sole governing director of the company and had absolute control over the Lee Air Farming Limited's business affairs. The second part of the facts are very interesting. Lee was not just governing director of the company, but was also chief pilot of the company as he himself was a qualified pilot. He drawn salary for being chief pilot of the company. His company also had an employee insurance. One day, while he was doing his duty in the plane got accident and he died, which I have mentioned in the third part. And then the fourth part, his wife Catherine Lee claimed insurance amount of 2,430 pounds under the Workman Compensation Act 1922 as the insurance that company has covered the risk of both injury and death of company's employees. The question then was whether Lee was an employee of the company. Insurance company told he is the governing director and the insurance hadn't intended to cover him but only the employees. The same was upheld by the Court of Appeal. However, the Privy Council gave judgment in favor of Catherine Lee, saying that it was perfectly possible for Mr. Lee to have a contract with the company he owned. The company was a separate legal person. That's the story of Lee versus Lee Air Farming Limited. Okay, with that we are done with case laws from Kolkata, UK and New Zealand. Now let's move to the next interesting case law from Mumbai. Oh well, Mumbai now, but it was Bombay then. Let's see what happened in Bombay. Bacha F. Guzdar versus Commissioner of Income Tax Bombay is a very important case law for both company is a separate legal entity as well as Income Tax Act, because here the discussion is about can an advantageous position for a person also be claimed by the company or not. Coming back to the story, it goes this way. Before starting the case law, one additional information. The lady in the below image is not Mrs. Guzdar. That is Mrs. Jahanavi Ganesh. That's my wife. I had this photo in my album, and when I first researched this case law, that image came to my mind. Searched and pasted here. I'm sure now you are coming out of sleep. That's precisely how our mind works. When we have to study, it behaves lazy and we start feeling sleepy. But we are very active to listen things like this. Right? Okay, let's get back to the case. Under the Income Tax Act, where there are agricultural activities as well as manufacturing and sales of those agricultural goods, there is an exemption from paying tax up to 60% of the income. Tax to be paid only for the remaining 40%, considering that as the manufacturing or sales income. Here in this case, B.F. Guzdar bought shares from a tea company, and for the dividend she got from those shares, she denied to pay the income tax up to 60% of those income, mentioning that tea company has done agricultural activities and hence there is an exemption and I shall pay tax only for the remaining 40%, considering it is from manufacturing and sales activities of the company. Her claim was the income in her hand should be treated as agricultural income up to 60%, as in the case of a tea company, on the ground that the dividend received by shareholders represented the income of the company, or to simplify, it is like she and company are one and the same, as her money invested via shares was utilized to run the company. However, the Honorable Supreme Court in this case said that, and I quote, though the income in the hands of the company was partly agricultural, yet the income when received by Mrs. Guzdar as dividend could not be regarded as agricultural income because a company is a juristic entity distinct from the shareholders. Further, Supreme Court also added that a company can own property and deal with it the way it pleases. No member can either individually or jointly claim any ownership rights in the assets of the company during its existence or on its winding up. Hope you understand. See, it is another matter that the money liquidated can be used for settling the creditors, etc. but that doesn't give any ownership to any subscriber because company itself is a juristic or legal person and it can manage things by itself and it owns the things which belongs to it. I hope that is very clear. Okay, that's the 4 important cases and that's not all. We have another 4 case laws, but we are not discussing them in detail. I will give few key points from the judgment for all those cases in my next slide. These are for the rank students. Students like me are already moved on to the next video because 4 case laws itself are too much for me. If you are still here, either you have a presentation on this topic or you want to score hell lot of marks in your exams. Whatever is the case, let's quickly walk through what judges has to say in below case laws. In SAE India Limited versus Parry India Limited, the Madras High Court said that the separate legal personality of the company is the bedrock of the company law. Bedrock here can be understood as foundation. So court here mentioned the very foundation of company law itself, the company's character of separate legal entity. Kolkata High Court in Rajendranath Datta versus Shibendranath Mukherjee case held that for any wrong done, the company must sue or be sued in its own name. That's again clarified that company and its subscribers are separate from each other. What happens when a company has certain dues? Can it be enforced against the managing director of the company? The answer was given in Sidana versus Rajesh Enterprises case where court held that, and I quote, where a decree has been issued by the court in respect of sums due against a company, the same cannot be enforced against the managing director. Hope you are understanding the clear separation of liability between the managing director and the company. Similar opinion was given in the case of Chamundeshwari versus Commercial Tax Officer. This judgment was given by Madras High Court where the Honorable Court held that a company being a legal entity by itself, any dues from company have to be recovered from company and not from its directors. Before I conclude and hand over this presentation to Nishan, we need to understand with all these case laws that there are a lot of advantages and some disadvantages with the company's character of being a separate legal entity. However, the advantageous side misused quite a few times, and when that reached the worst, a new doctrine got birth, and that is lifting of corporate veil. That's another very interesting topic to discuss, and for now I am taking your leave and handing over this presentation to Nishan.
Have you failed? If yes, then don't worry. You'll get a second chance. Just be ready. With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.